Happy New Year from StoryOne.
Welcome to the Story Lens podcast, where your story is our focus. We explore wealth, legacy, and purpose through a process that starts with deep listening and leads to one-of-a-kind strategies. At StoryOne, we believe the best planning begins with you.
Welcome back to the Story Lens podcast, where your story is our focus. I'm Kenny Conklin, and I'm here with my fellow StoryOne co-founders, Cameron Bond and John Christensen. At StoryOne, we believe that meaningful wealth planning begins with deep listening, and that the best strategies reflect your family's values, purpose, and long-term vision. Last episode, we talked about what is an estate at a very high level. In this episode, we're going to talk about the people you entrust to carry out your wishes. Those would be your executors, your trustees, guardians, powers of attorney. Choosing fiduciaries is probably one of the most important and emotional decisions that you'll make. So we'll just kind of get kicked off with this topic. And it's really, fiduciaries really means like who's in control, who's in charge, who's making decisions for you, really. So who are some of the key fiduciaries in an estate plan, and what do they do?
Yep. Well, let me start with a lens, just kind of explaining my view of the universe here. Mm-hmm. So I used to work at a trust company, gave a lot of public presentations on estate planning, those kinds of things. And often I would start the conversation with, who in this room has been a trustee or an executor before? Undoubtedly, 10 hands would go up, room of 100 people. Mm-hmm. Then I would follow up with the question of, who wants to do it again? Guess how many hands went up?
Zero?
Zero, yeah. Yeah. No, so it's the other thing that we tell people, it's the greatest honor that nobody wants. There are people that are gifted in that type of a thing, this type of a role, but it is often administratively heavy. It is a marathon often, not a sprint.
Time-consuming.
Yeah, and time-consuming. And so lots of times people like to appoint their most successful son or daughter, their super successful business partner, their whoever, but that person is also really busy, right? And so that's kind of the lens that we enter this conversation often, which is like, who is the right person to fulfill this role? But really kind of the roles, again, just kind of go over it in a will. In a will, you really appoint your personal representative or your executor, who's in charge of the assets, and then a guardian for minor children. So those are kind of the two roles that happen in a trust, or in a will, I'm sorry. Then in a trust, it's interesting, there's been some additional roles that have kind of become normalized. And really, the primary role that people think about is the trustee. The trustee is who's in charge of the assets. Mm-hmm. So the trustee is in a very important role. But then now there's one that's much more common. It's called a trust protector. And trust protector kind of has some special duties in that document that allow them to make some changes really for the benefit of the beneficiary, for the benefit of the trust. But then, it's funny because that trustee role, it can also be divided into like special trustee or corporate trustee or individual trustee. Mm-hmm. And so those are kind of the roles within a trust agreement. And then in a durable power of attorney, you appoint what they call an attorney in fact. People often say, I'm the DPOA. And it's like, actually, you're not a document. You're the attorney in fact. That's what the durable power of attorney appoints, right?
Right.
So really, you as the person that signs it are the principal. Mm-hmm. The person that you're appointing is an agent. So they're acting on your behalf from a legal standpoint. The other interesting thing that they've started to do more often, and I really like, is appointing a guardian for yourself. Because if there were a case where you were incapacitated, who's responsible for your person, for your physical body? And so appointing a guardian for yourself can also happen in that attorney in fact, or in that durable power of attorney.
And it's probably good to tell the people or ask them if they'll be the executor or the guardian or oftentimes that it just ends up that you are, right?
Yeah. That's right. Yeah. And it is, you see it a lot of times where, again, these are sometimes the issues that cause people to change their trust agreements or their estate plan in general, is that all of a sudden they're uncomfortable with who they've appointed as a guardian for their children, who is their executor, who is their trustee, those kind of things. And so it is, but to your point, Kenny, yes, it's really good to talk to those people ahead of time. That's important.
So if I've never been an executor before, and all of a sudden I am, what would I expect? Like, what would happen if all of a sudden somebody said, okay, somebody passed away, in their will they made you the executor.
Yeah.
What do I expect? What the process and what's going to happen?
Well, from a technical standpoint, you now have a bunch of duties, right? And these duties are really to the estate, which ultimately then are to the beneficiary. But a couple of those, like some of the most important, is marshaling and securing assets. So, we've been involved in cases where that's actually a pretty big challenge, because it's your duty to make sure, let's say that there's a elderly couple that are living together or elderly couple that is a second or third marriage, and maybe they have a prenuptial agreement. So his assets are his assets, her assets are her assets. They're living in a house together. She passes away. You're her executor. What assets in the house are hers? What assets in the house are his? All of a sudden, that's your duty to figure that out. And it is like literally securing the assets. And so as an executor, really it's, in most cases, it's your first thing you would do is contact an attorney and just say, hey, I've been named as executor. Hopefully that person that named you as executor has given you a heads up. So there's a few family members that I'm appointed executor for, and where you really get that warm, cozy feeling is that, once a quarter, once a year, that person that's appointed you executor sends you a balance sheet. Because then when they pass away, you know what you're looking for. Otherwise, it's literally like CSI. So, if, for example, Kenny, I was your executor and you passed away, day one, I'm trying to figure out, what do you own? Right?
And this is the time component. It takes
quite a bit of time. Yeah, but it is literally like, well, all of a sudden I'm looking through your mail. Where did Kenny bank? Right? Where did Kenny have his mortgage? I mean, all those things that are just, and it's interesting now.
And you have to go to each one of these entities.
Oh, yeah.
And
but lots of times you can't go to the entity because they're not going to talk to you until you go to court. Right? So you need to go open a probate matter. You need to get letters testamentary that says, actually, Kenny John's in charge, or whatever that is. So it's a super laborious. The other interesting thing that, do you still get paper statements for your bank accounts, Kenny?
On some, I do.
Yeah. But a lot of them are electronic.
Absolutely,
right?
Yeah.
So one of the interesting things now that really, quite frankly, the law hasn't caught up to is like, if I get all of my statements electronically, how are you going to figure out where I bank? You're going to sign into my email. How are you going to sign? I mean, just like the things you have to think about.
It's difficult to dual authenticate to someone who's deceased.
Yeah. It is interesting. Like the old,
Well, from an individual level for each one of us and everybody, to have that in place and say, here's the bank accounts, here's where things are at.
Right.
That helps out.
Oh yeah.
Whoever may need to do these things for us.
Yeah, and it's one of those things like personally, I keep a balance sheet, and on that balance sheet it has bank account numbers, has insurance policies with the numbers, who's the issuing company, those kind of things. So if something were to happen, my executor, my trustee can go start to marshal assets.
It's probably a good time in the podcast to recognize that John is my trustee, and he does not have my balance sheet.
And now everybody on the podcast knows that.
So I need to hire a financial planner.
That's right. Yeah. So really, it's just like if you think about it from I'm not even sure what analogy to use, but it'd be a little bit like if Kenny went on vacation and he's he sent me an email or a letter and said, I'm going on vacation for an extended period of time.
Probably golfing.
Yeah. You're responsible for everything in my life. Go take care of it. It's like, I'd show up and be like, okay, how do I do that? And it's just literally like CSI kind of thing.
Coming back to the greatest honor nobody ever wants.
Yeah.
It's like, congratulations. Here's an Easter egg hunt.
Yeah.
A few clues.
Yeah, that's right.
So that's an executor. What about a trustee?
Yeah, trustees pretty similar in that the benefit that you have there are things are already titled in the name of the trust. So this is where the difference between a will-based plan and a trust-based plan are starkly different. Because if I have a trust agreement and a bank account is titled in the name of that trust, I can walk in with Kenny's death certificate and the trust agreement, and if I'm the successor trustee, then I'm in charge of that asset, right?
Right.
I'm not going to court. It's not going through probate. It's not right. So like all of a sudden, like that's the stark contrast. So we had when I was at the trust company, we had a client of the bank that passed away, and his wife was the trustee. They owned an LLC. The trust owned an LLC. The husband passed away unexpectedly. So 10 days later, when the wife had the death certificate, she could continue to operate the business. She could do everything she needed to do to manage that asset. When had that not been in place, it would have been a disaster. So it is this thing where it's like, as a trustee, your role's a little bit easier. And hopefully, again, like what helps a lot is if you have a balance sheet or if you have a list of assets that are in that trust.
And you title things in
Right.
the trust.
Yeah. Yeah. Well, that's we could do a whole episode on
Probably will.
Ensuring that things are titled correctly.
Well, it's a good transition to like when we think about who's the right kind of person for that role. Like you can see how, I don't know what the average family has. They probably have
Trustee.
No, the average family probably has 7 accounts, right? They might have 2 or 3 insurance policies, maybe 5. They've got a house, sometimes a second house. They've got a boat. They've got 4 cars. I mean, just like all of that, right? You can see just like the administrative steps for each one of those assets. If you pass away with no plan, is like terribly painful. And if you pass away and the trust owns all of it, it's all titled appropriately. Still kind of a headache. You still have to have some administrative giftedness to wade into that and do anything with it in any kind of efficient manner. And so, sometimes people will default to be like, the trustee should really be my mom. She really loves my kids. She's a great lady. And you're like, I love your mom too. But she's 70 years old. And if we task her with this role as your trustee, like this is not a great plan. Yeah. So, maybe she's in there in some capacity, but like probably not your trustee. Yeah. And so, it's probably
she might be a better guardian than it.
Right. Yeah. Right. So it's a chore for sure. Like there's no question around it. Yeah.
Let's talk about guardian. Let's talk about that role.
Yeah. A lot of times, and that's somebody that's named in the will. And again, this is what gets most people out of the thinking about it and doing an estate plan because they've had children, right? And really what they're looking out for and thinking about what's the best interest of my child. And, in the state of Kansas, how it works is the state has a duty to appoint the guardian for your child. You technically are nominating some people to be guardian. So your child's not an asset, so you just can't give your child to a guardian. So really you're telling the court, if something happens to me, I'd like Kenny to take care of my children. Or if something happens to me, I'd like Cameron to take care of my children. And so really that guardian role is, like, again, in the state of Kansas, it's kind of interesting because you're really an adult at 18. However, from a standpoint of receiving assets, that's 21. And so it is a thing where the guardian would be responsible, not really for their assets. The guardian would be responsible for their person, like for their well-being, for their physical body. And so it is interesting when we think about that role as guardian, and then Suki and I, as we thought about it, it's really like, who aligns with our worldview? Who do we trust to take care of our children? Who do we think would raise our children similar to how we would raise our children? So like that's really a heart level question. But then from a standpoint of like a check and a balance, do I want the person that's responsible for my child also to be managing the assets, or also to be responsible for the assets? Because you could see where you can get into this really interesting, for lack of a better term, conflict of interest, where like in the case of like we have 4 children, 2 of them are now adults or careening toward being adults. But if we had young children and we were to pass away, now my children, the guardian may need a bigger house, right? Which we would want our trustee to buy a bigger house. Mm-hmm. But that house is an asset of the trust. The house is not an asset of the guardian, right? So it is this, there's a check and balance that we recommend when you're working in this situation where the guardian is, again, like when we think about it, when I think about it for my family, it's like, who would be really great at raising my children? Mm-hmm. May not be the same person, be really great at managing my assets. And so in our case, like, we've separated those duties, and that's what we recommend a lot.
Yeah.
And power of attorneys could be a bit like that too, where, you know, my sister's been in healthcare her entire career.
Yeah.
She's probably better suited to make healthcare decisions.
Yeah.
I've been on the financial side, so
Yep.
I'm probably better suited for that side of it as well.
Yep.
So there's the power of attorney as well.
Yep. There's a lot of times where, like in my estate plan, that's exactly what I've done. One of my best friends is a doctor. Well, he's a great guy to make decisions from a medical standpoint. But he's, you know, I wouldn't want to burden him to manage my checkbook or pay my mortgage or XYZ. So I've actually separated those duties in my estate plan.
Yeah, if he's listening, he knows he's not the right guy.
He
for
knows
the
that.
financial.
So going back to what you were kind of alluding to, you know, what makes a great fiduciary? What makes a great person? You know, and I think we've been alluding to it. Kind of depends on maybe expertise or time, or, you know. But in your minds, like, if we walk through these different things, what makes a great executor?
Mm-hmm.
And what are some things that maybe don't? And you should think about somebody else.
Yeah. Well, so one of the interesting things that we're just encountering really in our career is, you know, we've been in practice for 15 years plus. And so what we're seeing now is we're seeing a lot of families that we've worked with for a long time, their estate plans are starting to be implemented, right? And so it's interesting to see how some of those play out. But the thing that really strikes me as we work with these families is like the duration of this role, right? So to like keep that in your mind's eye or think about it. So like if you're going to be somebody's power of or attorney in fact for medical decisions, that stops at the end of their lifetime. Durable power of attorney for financial decision, that stops at the end of that person's lifetime. Mm-hmm. Being an executor, that role, I would say that on average to settle an estate, it takes, quite frankly, a year would be fast. I think most of them probably take 2 years to settle an estate. However, that trustee role, if you have a lifetime trust or if you have a multi-generational trust, like we have a couple families that we work with that the trustee has been in place for 40 years.
Yeah.
So all of a sudden you're thinking about, well, that's not like Kenny's out of town, I'm going to go over and mow his lawn. It's like Kenny's out of town, I'm responsible for everything, right? Mm-hmm. So it is this thing where it's like that role is a very important role. And the other thing that's interesting, just as you think about it, there's implementation, the administration of things, but then there's strategy, right? And there's times where it's like those two things really, in the perfect world, those two things would align, where it's like you have strategy that's driving your implementation and they're not working independently. But if the fiduciary, if you name a wrong fiduciary, it could happen where there's a lot of administration going on, but there's not a lot of big picture thinking going on.
Yeah, give us an example of a strategy type situation that you would come across.
Just a simple example. No, just this not a. Yeah, I'm sorry. Whenever you start talking about generation skipping tax, it's not a simple example. But as an example, there's trusts that are called generation skipping GST exempt, meaning that they're not subject to GST tax. And there's GST non-exempt, meaning they are subject to GST tax, which is at 40%. So that's a big number.
Big
right?
number, yeah.
So if I'm the trustee and I'm the trustee on a GST exempt and a non-GST exempt trust, and Kenny's the beneficiary, and Kenny comes to me and says, hey, I need $100,000 to join this country club. The GST exempt trust will be the last thing I spend, and the GST non-exempt trust will be the first thing I spend. So in this case, we want to drain the GST exempt trust and leave the we want to drain the GST non-exempt trust and leave the GST exempt trust in place. Mm-hmm. Because that GST exempt trust, by definition, is outside the realm of estate tax. Mm-hmm. So that's a super powerful tool to let it leave and compound. So that's one of those things where if you have a situation where somebody's not thinking about it in the lens of what's the best thing over the next 30 years, 40 years, 50 years, mm-hmm. Kenny could just come and say, hey, I need to join this country club. I need $100,000. And I'm just like, well, there's $100,000 in this GST exempt trust. I'll give that to Kenny. It's like, that's a strategic blunder.
Yeah.
So, and to be clear, we have not had that discussion.
No.
But I expect you to at some point.
Have thought about it. But we have not had that discussion, John.
That's just an example.
I know it is. Yeah.
Illustration. Yeah.
So when's it appropriate to have a fiduciary be more than one person, or can you have multiple people in these roles?
Yeah.
Yeah.
I think a place we commonly think about it or see it is, a common question in estate planning is like, okay, I'm gone. There's this pot of money out there for my children. At what point do they have control of the assets, right? And different families have all kinds of different expectations. Some families create all kinds of structure in their trust, but it's a common question like, okay, are they responsible at 25? Are they responsible at 30, 35? Do I always want a trustee involved? Well, sometimes what we see is we say, hey, when the youngest of the kids is 25, let's say there's 3 kids, all 3 of them become co-trustee on a trust. So like the original trustee is in place. They're still helping make decisions, provide some governance, maybe some wisdom. But then, when the kids turn 30, we go, okay, they've been trained. They're 30 years old. It's time to kind of release the reins a little bit, and they can become their own trustee. And then they can, then be responsible for those assets. So that's an example. They look a lot different, but a lot of times you'll see this period of time where there might be co-trustees who are making decisions together on assets. So that's one example. I know there's many more, but
yeah, and there's times from a tax standpoint, that you don't want your beneficiary to be trustee, because if they have too much control, the asset in that trust can be included in their estate. And again, we start talking about multi-generational type assets. You don't want that. And so there are times where it's just like it's better to always have a external and someone else be trustee. The other thing is just like the practicalities of naming dual or multiple attorneys in fact in a durable power of attorney, or multiple executors or multiple trustees. Like, if the person that you're naming is trustworthy and you trust them, I would be a big fan of naming one person. The risk of naming 2, and like we open accounts all the time, we help people sign legal documents all the time, but if everything that needs to happen needs to be signed by 2 people or 3 people, like if I have 4 kids, I name them, they're all executor or they're all attorney in fact, and they go to the bank to do something and they go, well, not all 4 kids have signed this. I mean, what a pain, right? I mean, you just took a job that was already painful and you amped it up a notch.
Well, and I think whoever is co on these things, that they need to get along and be rational. And I know my sister and I are on several things, but I do everything and trust her implicitly anyway.
Yeah, and that's what. And then my experience when my brother passed away is my sister and I, it was just a pleasure to work together.
Absolutely.
We were just high trust factor. It was just one of those things that was super easy. but we've worked with lots of families where that's not the case.
Well, the feelings.
We have a family right now that, basically, dad passed away. I don't know, 5 or 6 kids in the next generation that caused a huge division, and it was over something that was fairly minor. And this huge division is not like they're arguing with each other. It's like they're not even talking to each other anymore.
Mm-hmm.
And again, like this thought of like, if mom or dad would have known that this money that we're going to give our kids is going to cause division in the family, most of them would be like, burn it.
Right.
Send it to the church, send it to whatever.
Mm-hmm.
Like, I don't want an asset to be divisive. And so there is this thing where it's like having multiple executors or multiple attorneys. In fact, it not only can cause some inconvenience, it can actually cause some hard feelings.
Absolutely.
Yeah.
Yeah, and they're, these are emotional events. A lot of times there's lots of feelings you go through. So sometimes it is important to have a professional that doesn't have a is kind of outside of the scope of the documents and kind of helps shepherd things through.
Yeah.
Are there certain times when you're like, you definitely need a professional, or you need to really think about a professional? I mean, how would you walk through that?
Probably the most obvious example is when you're kind of dealing with special needs trusts. And so just really high level special needs trust means that the assets that are going for the benefit of that child or that beneficiary, it really makes sense for that to stay in trust forever, for there to be a trustee involved. They're probably receiving some benefit from the state. And so, those are complex to administer. There's no question about it. They're very niche. They're important. They're a really useful tool in that situation. But, to hand that off to Uncle George and have him be the guy who's making sure that the rules are followed, even though those rules are changing, it's just really high risk. So that's a good example of, we really need a professional trustee in this situation to help, create the proper guardrails and ensure that the benefits remain in place that are coming from the state level, whatever it might be. So that's one clear example.
I actually do have an Uncle George, so we're not actually talking about that.
We're not talking about you, Uncle George. I don't have an Uncle George.
Your Uncle George is fantastic. we got to meet him, so he's a really incredible guy.
Well, and the other time where it's like lots of times business owners, the primary asset on their balance sheet is the business, right?
Yeah.
And then there's lots of times where there's certain assets that are in the trust that the grantor wouldn't want sold. Real estate comes to mind, right? So if you're going to name a corporate trustee or a general trustee, an individual trustee, you might want to appoint a special trustee to be in charge of the business, right? To make business decisions. Like we work with a family that was in a very specific industry, and the owner had a friend that was in the same industry. And if he were to pass away, he wanted that friend to be the special trustee, because all of a sudden you need to decide what's the best decision, not for the family, but for this business. The other thing, and this isn't 100% the case, but real estate. So often commercial trustees don't like real estate because real estate there's a lot of risk involved in real estate. So, the old rule of thumb is like, if a corporate trustee is in charge of your trust and you have real estate, you need to have some very specific language in there because, and as a general rule, they would want to get rid of the real estate because it presents risk. So there are times where a special trustee is really important. And that's kind of like in a special needs trust, like a special trustee or someone to help you administer that is often important.
Yeah, and then, John talked about GST, non-GST a moment ago, and I think when you're getting into those more complex trusts, that also invites the need for someone who's at the table who really does. Either they're a trustee who has maybe some legal background or a deep understanding, or they're a trustee who knows that they can rely on good advisors to help navigate that. So it's not always necessarily the trustee has to be a professional, but they need to be supported by a good team to ensure that they,
And there are times where that, so from a standpoint of when we're doing estate plan design, I really like giving the trustee or successor trustee the ability to appoint a co-trustee. Because a lot of times a corporate trustee is like the best money you've ever spent. Because a lot of times they'll manage the assets, they'll do all the accounting, keep all the administration. A lot of times then they have internal attorneys that will help answer any questions. They'll do tax returns on time. They'll do your estate, they'll pay your estimated tax on time. And so if as a trustee, if I'm not really fluent in all those different things, if I can appoint a co-trustee that's a corporate trustee, and they're doing all the trust administration, and then I'm thinking more big picture about the family and collaborating with that corporate trustee, that's a role that I like. Because the other thing that happens from time to time is somebody gets appointed trustee, they're a little bit out of their depth or they're not that familiar. Well, now they need a team, right? There's this person that maybe has never had a team before, and now they need a financial advisor to manage the assets. They need a CPA to help them make strategic decisions. They need an attorney to help them make legal decisions. So there is like this role of like, if an individual is named trustee, there's a lot of times where they just need help.
Yeah.
So we've covered a lot on this episode.
Yeah.
Fiduciary, big word. Who's in control?
Yeah.
Who's in control of the will, the trust, power of attorney, guardian. Is there anything else you guys want to say as we kind of close this down?
Yeah. I mean, I just think that, again, just from a encouragement standpoint, I think that who you choose as your trustee, who you choose as your fiduciary is an important decision. So I think it is something that people should really think about it, so they can make the best strategic decision for their family. So, yeah,
and just navigate, like, as you think through that role, I would just encourage you to create space for a conversation. Because too often it's just a gut response. Oh, it should be this person. And then they just move on, and that's in the document. And you're like, had you spent a little bit more time fleshing out what it actually looked like, you might have named somebody different. So it's just kind of creating space to think through that, make sure that it's a good alignment.
Yep.
And on the flip side of it is, if you're asked, pray about it, think about it. And it's okay if you don't feel like you're the one who should do it, or if you don't have time, if there are reasons too, and not feel guilty about it.
Well, that's one of the interesting things that having worked at trust companies, and so a trust company is often appointed as a successor trustee, and this happens to individuals as well. You can accept or decline that role, right? So often in these estate plans that we review, or even ones that we help clients get drafted, a corporate trustee is the backstop. So it is a thing, like, if it's something you can't do, there's probably is some wisdom in not taking the job, because you are inviting complexity. So it's just one of those things that I think be thoughtful on both sides of it. Yeah. And it is one of those things, again, like, if I were to encourage those that have an estate plan, the thought of having a balance sheet that you send to your successor trustee on an annual basis, that's just a very loving, caring thing to do. And it's, just from a standpoint of, often people spend their entire life accumulating wealth, accumulating assets, accumulating stuff. So it is a thing where, like, it'd be really great to make a clean handoff to whoever's responsible for that. So, it just gives them a lot of traction.
So choosing the right people to carry out your wishes is one of the most powerful decisions that you may make. If you have any questions on any of these topics, certainly reach out to us, whether it's comments in the podcast or email or phone. We'd be happy to talk to you about the questions that you have.
Yeah.
And certainly thank you for joining us on this episode of the Story Lens podcast by StoryOne. Be sure to follow us on Apple Podcasts, Spotify, and YouTube so you never miss an episode. Until next time, we're grateful to have you on this journey with us. Thank you, John. Thank you, Cameron.
Yeah. Thanks, Kenny. Good job. Thank you for joining us on the Story Lens podcast. If you're navigating complex financial decisions, we're here to help. We know your story is anything but ordinary, and that's why we start there, because the right solutions are as unique as you are.
StoryOne Family Office, LLC, or StoryOne is a registered investment advisor, RIA, registered with the United States Securities and Exchange Commission, SEC. Registration as an investment advisor does not imply a certain level of skill or training, and the content of this communication has not been approved or verified by the United States Securities and Exchange Commission or by any state securities authority. StoryOne renders individualized investment advice to persons in a particular state only after complying with the state's regulatory requirements or pursuant to an applicable state exemption or exclusion. All investments carry risk, and no investment strategy can guarantee a profit or protect from loss of capital. Past performance is not indicative of future results. This podcast is intended for informational purposes only and is not intended as the sole basis for financial decisions, nor shall this be construed as advice for the financial needs of any individual. StoryOne is not permitted to offer, and no statements made during this podcast should constitute legal or tax advice. The information contained herein has been compiled by independent third parties, have been obtained from sources who are believed to be reliable. However, accuracy and completeness cannot be guaranteed by StoryOne.